matter of Houssein and others, and London Credited Limited and others.
Yes, Mr. Wheeler.
Lord, I was starting to deal with took her over yesterday afternoon, and perhaps I could invite your lordships to turn back to that decision.
Yes.
It's in the authorities bundle at tab 7. And the relevant passage I want to start with, if I may, is at page 132.
Is what?
132, my lord, behind tab 7.
Page or paragraph?
Page 132, paragraph 13. And this is a passage that your lordships were taken to yesterday, but I just want to summarise some key points that arise out of it. Because this is the passage of Lord Mance's speech that really sets the context for what is to come. And I think you were taken to paragraph 13 yesterday, but I just wanted to emphasise the passage, the bottom 2 lines of page 132. The board does not accept that this is an entirely inflexible rule which must be applied even where there are strong countervailing considerations of equity or unconscionability associated with events subsequent to a forfeiture. So the emphasis here is on forfeiture and relief from forfeiture, which is perhaps unsurprising. And then again, at paragraph 15, picking it up in the bottom 6 lines of that paragraph, just above letter E. The question is whether equity has any power to identify particular circumstances making it exceptionally inequitable or unconscionable to insist on redemption taking place on a basis which treats the loan as if it had remained continuously outstanding to date. So that point there, emphasising that one is looking at a sort of counterfactual situation, again demonstrates that this is necessarily speaking in the context of relief from forfeiture. And we then, against that background, come on to paragraph 16, where one has the former situation and the latter situation. And my learned friend said yesterday that when one is in the former situation, which of course where we are in this case, he said the discretion may be more sparingly exercised, but there's still a discretion available. Because he referred to Lord Mance talking about it being difficult to identify any reason why they should not, if unperformed, be performed as a condition of relief. This is difficult, doesn't say it's impossible. But while there are obviously caveats in the wording used by Lord Mance in relation to the former situation, it's not simply a matter of degree as to the willingness as to the court's willingness to exercise the discretion. When one gets on to the conclusion in paragraph 42, which is where the discretion my learned friend relies on is outlined, one sees that that discretion is focused entirely on the latter situation. It's not engaged at all on Lord Mance's analysis in the former situation. And one sees that both at the bottom of paragraph 16, where he says, in the latter situation, equities must extend to considering such matters. And it would, in the board's view, be remarkable if the principles of equity were so inflexible that it was unable to take any account of the circumstances making it inequitable or unconscionable to insist on treating the loan as if it had run continuously until relief was granted. And then again at paragraph 17, after the quote from the Lord's judgment in Lord Debenture Trust, the final sentence of paragraph 17, the last 4 lines on the top of page 134, the board accepts that as the standard rule, the board accepts that as the standard rule, but the issue in this case is whether exceptional circumstances may make it inequitable or unconscionable to apply the general rule in the latter situation identified in the previous paragraph. So the whole issue that Lord Mance identifies for consideration in his judgment is about the extent to which a discretion exists in the latter situation. It's not saying the 2 situations are the same, but in the former situation you just are more constrained, but the same approach applies. It's entirely focused on the latter situation and the discretion that is exercised there. And I'll come back to paragraph 42 in a moment, if I may, but I just wanted to sort of, moving through the speech in order, move on to paragraph 30, page 138, to look at what Lord Mance says about the redemption cases. And at paragraph 30, Lord Mance addresses equity's response to tenders or offers of repayment. And of course, my learned friend emphasises those words, which are refused or do not, for other reasons involving the lender's fault, lead to actual repayment. And he works through a number of cases. The first is Manning and Burgess. And my learned friends overnight have dug out a copy of that report. I don't know if it would assist
Yes,
to hand
I've
that
seen
up.
it, and the report
Oh,
says the mortgage
well,
was forfeit, but
yes.
I don't understand,
Well, if your
what
lodgers
it means.
have looked at it, and you would have seen that the report is barely any longer than paragraph 31, and I don't think really
Yes.
says anything that's not quoted by Lord
In
Mance.
those days, you granted a mortgage by conveying the property to the mortgagee with a
Yes.
promise to reconvey on repayment of the loan. So I don't understand what forfeiture has got to do with it.
It's unclear. It means there was a default in repaying when repayment was due, but I mean that's my slight speculation as to what it might be
but
meaning.
that is what it says.
It is what it says, yes. It's unsurprisingly accurately quoted by Lord Mance, but we can't really take it any further. But either way, what one sees is this is a case where the mortgagee said essentially what he wasn't willing to allow redemption to happen. The mortgagor tried to tender the money, but found the mortgagee not at home. And obviously in those days, the mortgagee not being home is more of an impediment than it would perhaps be today. But we don't have much detail of this case. It can't take matters very far, but clearly it involves an attempt to hand over the money, and that attempt is frustrated by the mortgagee. We then, at paragraph 32, have Webb and Cross, which is a decision of Mr. Justice Parker. It's cited for two propositions. Firstly, that a tender for the purpose of preventing interest running need not be such as a tender as would afford a defence to an action in law. I'll take your lordship to that in a moment, but essentially that means you don't have to pay the money into court as one would if one was defending a debt claim. And then secondly, it said the court can take account of misconduct by the mortgagee when settling the terms of redemption. And Rourke and Robinson is said to be an example of a case where that power was exercised. We then, at paragraph 33, have reference to Rourke and Robinson. And there it said Mr. Justice Warrington held in a redemption action that the technical rules as to tender and whether or not the mortgagor had complied with them were irrelevant. And then there's reference to citation of a test set by Lord Selborne in Cotterell and Stratton, which sets out in fairly broad terms a discretion. And it's then said, and that was therefore capable of depriving him of the right to interest subsequent to 17th of August 1909 and costs in the action. It may be helpful, my lord, to pause at this point and just to look at those two cases, because when one looks at them, it very much puts what Lord Mance says here into context, and when one understands the full facts of those cases more fully. So perhaps if I could invite my lords to turn to tab 3 of the bundle, page 17. Rourke and Robinson is the first of those cases chronologically. And one sees in the head note, this authority is said to be authority for the proposition of the fact that it's duty of a mortgagee on being paid by the mortgagor the principal, interest and costs, and contemporaneously with such payment to hand to the mortgagor the title deeds together with a duly executed reconveyance of the mortgaged property. And of course that's unsurprising. It's the quid pro quo of payment. You pay the money, you get the property back. If I could invite the court to turn on to page 21 using the bundle pagination. We see there from the first paragraph of Mr. Justice Warrington's decision, one sees the very narrow confines of the dispute. The action is a redemption action, but very shortly after its commencement, the principal money and interest up to the date of payment, together with certain costs incurred by the mortgagee, subsequently to the 17th of August, when a tender had been made, those were paid. And the controversy, the only controversy between the parties, is whether the mortgagee is entitled to retain the interest subsequent to the tender on the 17th of August, and the costs after that date, and the costs of the action. And one sees that what happened, picking it up at the bottom of the page, In March, the mortgagee gave notice to the mortgagor requiring him to pay off the mortgages in 3 months. That notice expired at the end of June. The money wasn't paid, but then correspondence passed between the solicitor for the mortgagor and the mortgagee, where drafts of the reconveyances proposed to be executed were settled. So there was no dispute about those forms, but he then says the mortgagee solicitor deliberately, considering himself to be acting therein in the interest of his client, positively declined to get her to execute the reconveyances as escrows or to do anything which would ensure the delivery of the executed reconveyances upon payment of the money. And he says the whole question is whether the solicitor was right about that. And we then see at the bottom of page 22, we see reference to the tender on the 17th of August. This is the case where money was literally put on the table. But in return for the money, what was required was reconveyances. And it said at the bottom the deeds were there and could have been taken, but the reconveyances were not. And the mortgagee was making threats to sale and wouldn't do so. 2 points I just want to make on that. Firstly, one sees this is a case of refinancing. The money came, and we see at the start of that final paragraph on page 22, the mortgager and his solicitor and the manager of the bank, which were prepared to lend the money to pay off the mortgages, attended at the offices of the solicitor of the mortgagee. So this is a refinance case. So these are not new in the way that my learned friend was seeking to suggest on raising new problems. It's a well-established situation. But secondly, my learned friend also suggested yesterday that perhaps in the past, tender was a unilateral act, whereas in modern times, when one has to repay via the bank system and one tenders through refinancing, it's more of a bilateral act. Whereas one sees from this case that actually tender to discharge and redeem a mortgage has always been bilateral, because you've always had to have the payment on one side and then the reconveyance on the other. And you inevitably can't have the payment without the reconveyance. So it's always been a bilateral process. And one sees, as one sees here, that the lender can frustrate that process in 2 ways. He can say, I don't want your money, which one suspects is relatively unlikely. Or he can say, I'm very happy to have your money, but I'm not going to reconvey the properties, or I can't reconvey the properties. Now, both equally frustrate the process. Both equally make the tender impossible. But of course, where one's saying, yes, I'm happy to have the money, but I can't reconvey, that's slightly different in terms of willingness to accept the money and willingness to accept the tender than the situation where someone says, well, I just don't want the money at all. But that's perhaps why one gets talks, not just of offers of the money, but offers of not just of tenders, but offers of the money, because where the money is offered, but the mortgagee says, well, I can't reconvey, that obviously puts you into a different situation, because you know there that the quid pro quo payment can't happen. And when one looks at how this was resolved, midway down page 23, Mr. Justice Warrington says there was an argument as to whether it was a conditional tender and therefore no tender at all. And he says, I doubt very much whether the technical rules relating to tender are of much importance, but if they are, it wasn't a conditional tender. So this was a case in which money had been tendered, but the basis on which the case is decided ultimately is at the bottom of page 23, where he says essentially, well, the mortgagees were in the wrong in their failure to have the reconveyances available. And that's the basis essentially on which it said that interest ceases to run. But of course, the mortgagee was only wrong to refuse to reconvey against the context of the offer of repayment by the borrower. If the borrower hadn't been seeking to repay, it wouldn't have mattered that there was no reconveyance, because there'd be no right to reconveyance. So on any basis, the tender, or even if not a tender in strict technical terms, a serious attempt to repay the money with actual money being offered, is critical to the decision and is an absolutely central part of the context. Then at the bottom of page 23, we see Mr. Justice Warrington turns to the question of costs. And then we see at the top of the next page, it's in this context, and only this context, the decision of Lord Selborne and Cotterell and Stratton is cited. And of course, that's the citation that's referred to by Lord Mance. But one sees here that this is very much focused on the question of costs, where, of course, the court has much more discretion, and the discretion is much more large in the way it still is today. But this is not referred to at all in the context of the substantive question of whether or not liability for interest should be mitigated. So that's Rourke. If I could then turn to the next divider at tab 4, Webb and Cross. And this is a decision of Mr. Justice Parker shortly after the decision in Rourke that we've just looked at. And the relevant facts are seen from the judgment on page 29. Picking it up just 3 lines above the red bar. You see, on June the 21st, the mortgagee solicitor left for a short holiday, having arranged, he thought, with the plaintiff's solicitor that nothing should be done until his return. And then after that, the plaintiff's solicitor called at his offices and in the solicitor's absence told his clerk that the plaintiff was prepared to tender principal interest with a reasonable sum for costs. And he didn't ask for any appointment for making a tender, but then he returned again a few days later without an appointment and said he'd come as a matter of form, top of the next page, to tender the principal interest and 3 guineas for costs of reconveyance, and undertaking to pay any further costs. He produced a draft reconveyance, and he intimated that the money he was prepared to tender would only be paid in exchange for proper reconveyance. And the response was, well, it's impossible to reconvey, as you know, because there's difficulties in getting the reconveyance settled. And there were various complications in the background of all of this, that one of the original lenders had actually been a fraudster who disappeared, and then others had taken over the estate that was the lender. So there was various complications in that regard. And then we see the question is whether the circumstances that happened at this meeting was sufficient tender to prevent interest being thereafter charged. And the answer is no, because when a tender is made conditional on the execution of conveyance, it's necessary that a reasonable time should be allowed to obtain the execution of the conveyance, especially when the parties are not the conveying parties are not the parties to whom the tender is made. So in other words, you have 2 cases, both of which money was produced, in one of which, the first of which in Rourke, where it was said that the mortgagee was at fault in not being able to reconvey the property, and the tender failed for that reason, and therefore interest ceased to run. In this case, you have again production of the money, an offer in that sense to repay, but it failed on this occasion, not because the lender was at fault, but because the borrower was at fault, essentially turning up trying to repay and redeem when he knew very well that it wouldn't be possible to reconvey the properties, but at the same time insisting on that reconveyance. Those are the circumstances, and one sees a very different outcome given which side the fault is. And at the top of page 31...
It's odd on the facts, though, isn't it? Because Mr. Garrett's whereabouts were unknown. He was the fraudster, I think, as you described.
Yes.
Does that mean that the mortgage was irredeemable?
Well, there were difficulties in doing that. It was the mortgage. He was acting on behalf of an estate. Once he left, others then took over acting for the estate. And there were discussions underway as to whether the matter needs to come before the court in order to get an order to essentially work out how to deal with all of this. And that hadn't been resolved. And so that difficulty remained. Everyone knew about that difficulty. Everyone knew it hadn't been resolved. And everyone knew that the solicitor was absent when the tender was sought to be made.
I suppose these days the master would be given power to execute the reconveyance.
Yes, I mean, I'm sure there would be an answer to the problem, but the point is that the parties at this stage were still discussing it, right. And it was essentially, therefore, impossible to reconvey.
I haven't looked at this properly, but at the bottom of the page there's a reference to getting a vesting order. don't know if that was
Yes.
the way around it.
Yes, I think that probably was the way around it. But one sees at the top of page 31, the tender was made without giving the mortgagee notice of the mortgagor's intention and on a condition which there was no possibility of the mortgagees being able to fulfil. Made to a person not authorised to receive it and being no opportunity to procure authority for that purpose. Under these circumstances, I'm of opinion that the tender was not such as to deprive the mortgages of their right in equity to interest, any more than it was such as to afford a good defence to the covenant at law. He then turns on to costs again. And you'll recall that Lord Mance cites a passage where Rourke is referred to by Mr. Justice Parker. And we see that on page 32. And about 3/4 of the way down the page, Mr. Justice Parker says, no doubt the court can and will, in settling the terms on which a mortgagor may be allowed to redeem, take into consideration any misconduct on the part of the mortgagee, and sometimes, because of such misconduct, relieve the mortgagor of interest or costs which, but for the misconduct, he would have been bound to pay. Rourke and Robinson was preeminently a case for the exercise of this power. So we see there the reference to the term any misconduct. But given what we've seen about the facts of Rourke and Robinson, he was referring to misconduct against the background of an attempt to make payment of the sums due from the mortgagor. Now, one might say, well, one can read that in more general terms, but there's nothing in the authorities to suggest that there's a discretion to deprive the mortgagee of the right to interest as a result of misconduct in circumstances in which there's been no attempt to repay the debt. That is always central. And in all of these cases, we see that feature. Either the debt has actually been repaid, or there's been a very clear and obvious attempt with actual money to make that repayment. So, having gone through those cases, perhaps I could turn back to...
I'm not sure this helps at all, but this is all about the costs of the vesting order, really, is it?
Well, I think that probably partly what, in practical terms, underlay the dispute. That may be right, my lord. I don't think that's quite the basis on which it's...
But it looks as though the mortgagor wasn't willing to pay the costs of the vesting order.
Yes, they were arguing over that, essentially. Yeah. I think that's probably right. But that's not the basis for the decision. So if I can then turn back to Chukarova, having put those, it's at page 139 behind tab 7 is where I'd got to. I'll put those references into context. And I pick it up at letter E on bundle page 139, paragraph 33. One sees, having referred to Rourke and Robinson, Lord Manson refers to Lord Middleton and Elliot, which was another case where reconveyance was impossible because then in that case the mortgagee had lost the title deeds and therefore couldn't reconvey them and so was deprived of interest. Then at paragraph 34 we have the Privy Council case in Venkatarayanim, I think, and Zamindar of Tumi. But I'm not sure that takes very far because as one sees 3 lines before the quote, as the board reads the Privy Council's decision, and contrary to the impression given by the head note, the Privy Council rejected that question as relevant, the question being whether or not there had been a dispensement of the need for tender. And he considered the real question here is not whether the money was within the power of the appellants, but whether the mortgagee in the letter he sent definitely and unequivocally refused to accept the monies were it tendered. And the Privy Council didn't read the letter in that way, so the appeal failed. So that, I don't think, takes matters terribly far. But we then get to the conclusion of paragraph 35, where it said the authority shows that equity will consider whether the mortgagee by his conduct or fault may have disentitled himself from insisting on the usual conditions on which equity insists for redemption. But when one looks at those cases, and this is why I went to Rourke and went to Webb, they all show that the relevant conduct or fault consists of rejecting or rendering impossible an attempt to discharge the outstanding debt by making payment of it. None of the cases arise outside of those circumstances. And certainly none of the cases demonstrate equity intervening to allow the recovery of interest while also permitting the debt to remain outstanding and undischarged. And so the context in which one sees this reference to, it's not said to be a discretion, it said equity will consider. But one is, the context of this is the same context which forms the background to the whole of this part of the judgment, namely the question of the actual or attempted discharge of the contractual obligations. And of course, on the facts, as we've seen, the obligations had been discharged, subject to the question of being reopened by the relief to forfeiture. And in a case of tender being refused, the tender is an attempt at performance, and it must be continue to be possible to give effect to that attempted performance. We then have reference to various authorities that are said to lead to a different conclusion, and they really are authorities to the effect that a tender stops interest running only if money is kept ready to pay over to the mortgagee. And although it's suggested that they don't lead to a different conclusion from the conclusion at paragraph 35, no doubt is cast on the principle that money has to be set aside. And we then at paragraph 40 have reference at the bottom of page 140, paragraph 40, reference to Edmondson and Copeland. And there's a quote there where Mr. Justice Joyce says, you can't relieve the mortgage off from payment of interest down to the date of actual payment because he's had the mortgagee's money, never actually set aside the amount for the purpose of payment. And Lord Mance says, well, this passage can be read as a hesitant statement of principle, but it can also be read more of a flavour of a conclusion reached as an exercise of discretion and an absolute rule of law. So there we come back to the question of, is all of this about an exercise of discretion? And if so, how broad is it? Or is it a rule of law? But there's no doubt cast on the general principle that there's a requirement to set aside the money that's being tendered, whether that goes to the exercise of discretion or whether it goes to a more rule-based system, which is perhaps neither here nor there for present purposes. Either way, it's a plain requirement. And one sees that in the conclusion, of course, that on the facts of this case, the court insisted that, or the court determined that liability for interest was only relieved entirely for the period where the money was set aside. After that point, interest started to run again. Having looked at the authorities, if I can then go on to the conclusion at paragraph 42. And we've already seen reference to the conclusion that equity can and should respond by a special order as to interest or costs in exceptional situations. One needs to put that in context by looking at paragraph 44. Paragraph 44 is in quite strong language in my submission. He says, firstly, that it's no way suggesting that equity recognises any general or open-ended discretion. And then says, the board's reasoning and decision in this case are based on and confined to what it sees as an exceptional situation. And he then goes on to say in the final situation, the unusual facts of this case are, in this respect, probably unlikely to be repeated. Well, there's 2 points I want to make on that, if I may. Firstly, that really amounts to a very, very stark warning that this discretion that's outlined in paragraph 42 ought not to be extended or expanded, really very much seeking to confine its exercise to the particular facts of this case. But secondly, if Lord Mance is saying that this discretion that he has identified is one that's to be exercised only in these very exceptional cases, when one then looks back at paragraph 42, one has to ask, well, is he in paragraph 42 talking about a discretion that applies generally in the context of cases where there's an attempt to redeem a mortgage and one wants to mitigate liability for interest by reference to a tender? Because that, as one sees from the authority, is not a particularly exceptional situation. There's a raft of cases on that where the courts reach the same sorts of conclusions and apply well-established sets of principles. It's not something that's highly exceptional or unusual. If Lord Mance is saying that the discretion in paragraph 42 is such a highly exceptional discretion only to be exercised very, very unusually, that, in my submission, suggests that what he's talking about in paragraph 42 is an exercise of discretion in the context of the terms on which relief from forfeiture should be granted, not the situation where you have a tender to repay a mortgage and one seeks to avoid liability for ongoing interest, but that the question on which the court was actually focused in this case, namely the terms on which relief from forfeiture should be granted. Certainly that makes more sense of the notion that this discretion is one to be exercised only in very exceptional circumstances.
I'm not quite sure I follow how that works with the first sentence of paragraph 42.
Well, I do. I think I understand why your lordship asked that question. I think this is essentially following on from the analysis in points 7 and 8. And essentially, the court is drawing from that, those cases, the notion that there is scope for a general equitable discretion. But as I say, those cases can't be regarded as exceptional to the extent that this one is. Those cases don't depend on a general discretion. One has the debate as to whether or not those authorities set down a set of rules or a set of discretionary principles, but there's no suggestion that it's an open-ended discretion that allows the court just to, as it were, do what it thinks is just in the appropriate circumstances. Whereas when one's talking about the terms on which relief from forfeiture is set, there, the whole essence of the conclusion and the whole, the reason I took the lordships yesterday to what Lord Sumption says is the difference between the majority and the minority. The whole point of what the majority are concluding is that there is a general discretion in the context of setting the terms for relief from forfeiture. And yes, it shouldn't be exercised terribly frequently in this exceptional way. But that's the focus of it. And so, yes, there is some suggestion that it follows on from the cases looked at in points 7 and 8. But as a discretion, when one looks at the scope of it, it only makes sense, in my submission, if one reads it in that context. But even if that's wrong, even if it's broader than that, well, firstly, of course, insofar as this is talking about mortgage tender cases, it's entirely obiter, because that's not what this case is about. But even then,
if you go back to page 122 in the Bible, the Privy Council set out in the annex to its previous judgment what it wanted to be addressed on.
yes,
So they say that they've concluded it's necessary for relief from forfeiture to be sought, that it's
Yes.
available in principle. And then they ask about the conceptual basis,
yes,
and then they want to be addressed on the historical basis on which equity operates. Any light thrown on the correct analysis by the parallel jurisdiction in relation to section 146 of the Real Property Act,
yes,
and relevant authorities, some of which they list, and then
Yes.
they set out the various alternatives and what they want to be addressed on. So I think that does make it clear that what they were considering was relief against forfeiture.
well, yes. And that, of course, is the entire essence of what the case is all about. Even if one reads, as my learned friend says one ought, the discretion in paragraph 42 more generally, as I've said, the focus of all of this is on cases where the repayment of the mortgage debt is rejected or made impossible or delayed. It's inherent in those concepts that repayment has been attempted. None of the cases suggest that when one talks about an offer of repayment, it can be anything other than a serious, immediate and unconditional attempt to discharge the contractual obligation in question. And this comes back to the point I made yesterday about where one gets into the nuances. It may be that a repayment attempt can be sufficient, even if it doesn't meet one of the detailed requirements for tender, or where meeting one of those detailed requirements is rendered impossible by something that the lender does wrong, like a refusal to produce the deeds. But what it can't be, and what we don't see in any of the cases, is something so fundamentally different as to not to involve an attempt at payment at all. Second, it's inherent in all of this that the reason for the repayment failing is some fault on the part of the creditor. And in this case, there was no finding of fault on behalf of LCL, and I'll go on to address what my own friend says about that in a moment. And then, thirdly, in paragraph 42, Lord Mance says the situation for what he describes as an exceptional situation may exist where there is a tender or offer of repayment, particularly backed by monies actually paid into court. And my learned friend says, well, that reference to such a situation may exist implies that there are other circumstances in which such a situation will exist too. And whilst one can't perhaps rule anything out entirely, none of the cases cited demonstrate disallowing the recovery of interest in any other situation than where there's an attempt to repay. And there's not one case that is equivalent to the sort of conditional offers we have in this case. And the court's already seen
Well, I mean, yes, it's not a particularly clear passage, I have to say. One reading is that Lord Mance is not saying that where there is a tender or offer, one backed by monies paid into court, then there must be a situation. I mean, he's saying there may be such a situation. He's not necessarily saying, and there may be others.
Well, that's right.
What he's saying is it doesn't necessarily follow from an offer or tender.
Yes, maybe that's
that equity will intervene.
Maybe that's the better reading, my lord. It's certainly a narrower reading, but
I mean, it may well be he's not trying to be too definitive in something that isn't absolutely crucial to what he's deciding anyway.
Well, I suppose one way to look at it is this. One has a fairly well-established chain of authorities, many of which are cited, that refers to the principles where how equity approaches the question when there's an attempt to redeem a mortgage and there's a tender which is rejected. This paragraph can't be understood as effectively running a coach and horses through that and restating the law on an entirely different basis. It has to be understood and read in a way that's consistent with those authorities. And to the extent that it is varying the law, its focus, as I say, on relief from forfeiture, not a different part of the law entirely from that which the court is concerned with.
Yeah.
And your lordship referred yesterday, I think, to the terms on which relief was granted by the majority and the fact that interest ceased to run only for the period in which the money was set aside. And that is a further indication of the importance of that point. Can I also then look briefly at what Lord Newberger said at paragraph 130 on page 164. Because he refers at 130 to the importance of where the valid tender is made. The principal remains outstanding and interest continues to accrue under the mortgage unless after the tender the mortgagor sets aside what is due for the mortgagee. And he cites a number of cases in support of that proposition, one of which at 132 is what he refers to as a careful analysis of the New Zealand Court of Appeal in Devon Nominees and Hampstead Holdings, and I'll come back to that in a moment if I may. One sees also at 132 that Chukwueze challenged the fundamental proposition that money has to be set aside, and that was rejected. At 136, one has the rationale for that position explained by Mr. Justice Joyce in Edmondson. Essentially, the mortgagor has use of the money. Why should he retain the benefit of the use of the money without paying interest? And of course, that's precisely what the appellants are seeking to do here. And finally, at page 178, just for completeness, one sees that law assumption adopts the same approach at around about, well, at the top of page, paragraph 136 on page 178, where he refers to the long-standing principle that to stop running of interest, money must not
Sorry,
be.
I've lost you.
Sorry, my lord, it's page 178,
Yes.
paragraph 186.
Yeah.
And
We're in that paragraph.
yes, sorry, I'm just
This is Lord Sumption.
yes. It's just about letter D, my lord. The reason why the common law does not contemplate the result is the long-standing principle that to stop the running of interest, the money must not just be tendered, but held available thereafter if it is rejected.
Thank you.
That's common law tender.
It is, my lord.
And actually, the next sentence is an extension of that.
Yes.
Um,
But one sees it equally in the mortgage interest cases as well. Lord, I said I would come back to the decision of the New Zealand Court of Appeal in Devon Nominees and Hampstead Holdings. It's referred to by Lord Newberry. I wonder if I might pass up a copy of that. It's not in the bundle, unfortunately. But it is quite enlightening, particularly on the facts. If I could perhaps pass up a copy.
While we're on the subject of authorities, can I just refer to Mr. Alexander's judgment? He cited, let me find it, a case about conditionality.
The decision of Mr. Justice Dankworth.
No, it was another one.
Graham and Seal,
Yes, I think so.
page 223, paragraph
223. Yes, thank you very much. I couldn't find it, I have to say. On Westlaw, Westlaw says there is no such case, and putting in the citation reveals no results. But a look at Fisher and Lightwood suggests that it's reported in the Law Journal Chancery rather than in the Chancery reports.
Right.
Because I did ask Mr. Cowan yesterday what had actually happened in that case
Yes.
in terms of the form of the tender. And so I was trying to find out what the answer to that was, but unsuccessfully.
Right. I'm afraid
if somebody can actually produce a copy
yes,
of the report, which I think is not the citation that Mr. Alexander gives, I would be grateful.
yes, of course, my lord. I'm afraid I haven't attempted to look at it beyond what's written here, but we can certainly consider it's a 2013 case, so we can be quite confident it's not an AI hallucination that generated that.
Well, no, the case does seem to exist.
Yes, I'm sure it does. I'm sure it does. So if I could turn then to Devon Nominees, just picking up the facts from the head note, one sees that the respondent mortgagor was due to pay the appellant the principal sum of $158,000 in December 1977. Mortgage provided for payment at 19%, reducible to 12.5% for prompt payment. There was then the mortgagor sought an extension of the term in December 77. In June 78, the mortgagor sought to repay, and the mortgagee insisted that the mortgage had been varied and maintained, and that it was entitled to be paid in terms of the alleged variation, which the mortgagor refused to do. So there was a dispute here as to the terms of the mortgage. And if the mortgage had been varied, more would have been due, and the mortgagor was insistent on that. And the mortgagee said, well, I only have to pay you the lower amount, absent of a variation. And it was found at first instance that there was no agreement to vary the mortgage. So the mortgagor was on the wrong side of that argument. Though he insisted on payment of the higher sum, that he was unsuccessful in establishing that. And the judge held, at first instance, the mortgagee had taken a wrong stand in maintaining its entitlement to be paid in terms of the alleged variation, and that by its actions had effectively precluded repayment of the mortgage. That's essentially my learned friend's argument in this case. Mortgagor's liability for interest at 19% would have ceased in June 1978 if it had given 3 months' notice in writing. As it had not given the required notice, its liability ceased on the 30th of September. And there was an appeal against that, with the mortgagee saying he was entitled to interest at 19% from the period from the 30th of September to 9th of July 1979, when the mortgage was actually repaid. And the first instance decision was overturned, and one sees from the head note the mortgagor couldn't bring an end to its liability under the mortgage merely by indicating its willingness to pay the mortgagee on the release of the mortgage, the principal sum owing under the original mortgage, with interest thereon at 12%. The offer fell short of the making of a tender. To stop interest running on the mortgage, the mortgagor ought to have made formal tender of an amount sufficient to pay off the monies due and owing under the mortgage. An assertion of its willingness to make such a payment was not enough. And if I could ask you to turn on to page 479, picking up at line 9, at the end of line 9, on 30th of June 1978, the mortgagor's solicitors wrote to the mortgagee's solicitors, pointing out inter alia that the principal sum owing under the mortgage was only $158,000, and denying liability for the alleged shortfall of interest and various other items for which it might have been liable had the proposed variation been finalised. And of course, they were right, as subsequently found, to deny liability for matters that arose from the variation. The mortgagor intimated that it wished to repay the mortgage without delay. And correspondence then ensued, and no agreement could be reached because there was this debate over whether or not the variation had happened. And one sees then at page 482, at line 11, I think it is, the question is identified whether the mortgagor could bring to an end its liability under the original mortgage merely by indicating its willingness to pay to the mortgagee on the release of the mortgage the principal sum owing under the original mortgage, with your interest at 12.5%. Mr. Milligan said it could. Mr. Corey said that more than an offer was necessary. The mortgagor could achieve this result only if it made tenure an amount which was sufficient to meet the sum found to be owing. And then at line 26, it said it's common ground that no tender was made at any time, but the argument, picking it up line 31, or line 30, Mr. Milligan contended that the mortgagee had given to the mortgagor a clear indication that it would not discharge the mortgage, save on the basis that the variation increasing the principal sum had been agreed upon, a view that which Mr. Justice Quilliam didn't accept. He submitted that its actions in doing so amounted to an unequivocal refusal of the proposed tender sufficient to stop interest running. So essentially it's saying insisting on more money than you're entitled to is enough to stop interest running. And at page 483, one sees about halfway down at line 28, the argument that if a mortgagee seeks from his mortgagor something unreasonable by way of repayment, the latter need make no tender. And Barrett and Goff Thomas is referred to as authority, suggested that there was two inconsistent lines of authority on that point in that case. And those lines of authority are gone through. And one sees 484, the next page, at the bottom of the page, the court says these cases are clearly authority for the proposition that a mortgagor must not only make his tender, but hold the amount tendered available, even though it's been refused by the mortgagee. Then there are other cases referred to in Barrett and Goff Thomas and cited for the contrary proposition, namely that when the delay in redemption is caused by the wrongful conduct of the mortgagee, he is not entitled to claim interest. And the first of those is Lord Middleton and Elliot, which of course Lord Mance referred to. And we see Thornton and Court and James and Rumsey are the other three cases referred to. And one gets the conclusion at line 46 about these cases. We agree that they turn on their own facts, but do not consider them to be necessarily inconsistent with the principles set out in the other line of cases. Rather, do they represent a qualification to the general rule that a mortgagor who wishes to stop interest must make proper tender of the amount owing. In Middleton, Elliot and James and Rumsey, the mortgager's inability to repay rose through the inability of the mortgagee to produce the documents of title. And of course, we've also seen Rourke and Watt as examples of that. The willingness of the mortgagor to pay the amount owing was accepted, and his capacity to do so was never doubted. To have allowed the mortgagee subsequently to set up a lack of tender by the mortgagor so as to continue his liabilities to interest would have enabled the mortgagee to take advantage of his inability to perform his part of the settlement, namely to hand over the title deeds. Well, that's the point I made earlier about the reconveyance being the other side of the coin to payment. But he then says, the general rule remains. A tender of the amount due on the mortgage at a time when a mortgagee is bound to receive it stops interest from running, but there must be an actual tender.
Sorry, where are you now?
Top of page 486.
Oh, I see, yes.
And the conclusion, further down on 486 at line 18, to stop interest running on the mortgagor ought to have made formal tender of an amount sufficient to pay off all monies due and owing under the mortgage. An assertion of its willingness to make such payment was not enough. There was no unequivocal refusal of a tender or wrongful conduct by the mortgagee, such as to excuse it. So even though the mortgagee was on the wrong side of the argument as to how much was due and owing, and even though the mortgagee was insisting on more that should be paid than was in fact found to be due, still it said there's no wrongful conduct by the mortgagee, such as to excuse the absence of tender. And just finally, because it's referred to, I think, by Lord Newberger as being authority on the question of money that needed to be set aside, and one sees a paragraph, line 42 on the same page, there the argument is mentioned about money you must keep the money ready to pay over to the mortgagee to stop interest running. And it says some of the cases appear to support that proposition. Here there is no tender, letting alone set aside of funds, so the point doesn't arise. On that account, we express no opinion on it. So they don't really deal with that particular point. But this is very strong persuasive authority in my submission. It's consistent with the decision on Kinnaird and Trollope that I cited yesterday, that shows a mere offer in the sense of a proposal of payment on terms is not enough. And being on the wrong side of a dispute over the quantum of the debt isn't sufficient ground to avoid the need for tender. So that's, well, that's all I want to say on the law. Perhaps I can then move on to focus on the judge's treatment of Chukarova and the tender points, and deal with what my learned friend says in relation to grounds 1 and ground 2. And perhaps I could just invite your lordships to turn up the judgment in the core bundle at page 100. One sees there, paragraph 65, the judge sets out paragraph 42 of Chukarova. Paragraph 66, he records my learned friend's submissions that these were exceptional circumstances. And then in paragraph 67, he accepts my submission that Chukarova doesn't mean that LCL was obliged to accept an offer of payment that wasn't compliant with the contractual scheme of the facility letter. And he then says LCL was entitled to refuse any offer that didn't involve the payment of the sum due in immediately available funds. And this is what perhaps leads to the slight sidetrack, looking at what clause 9 means. But really all it's saying is that the contractual obligation is to repay the loan, and that has to be done in immediately available funds. So for example, a post-dated cheque wouldn't suffice. Similarly, you can't discharge the repayment obligation by saying you'd repay in a month's time. That fairly obviously, it doesn't suffice. But more broadly, the appellant's repayment obligation was the obligation to repay on the terms of the facility letter. They couldn't vary those terms or insist on making payments subject to some new extra contractual conditions. And this really is entirely consistent. However one reads Lord Mance's judgment in Chukarova, and however one reads the scope of that discretion in paragraph 42, he's quite clear that the usual position is that where there are contractual obligations that remain outstanding, any intervention by equity is circumscribed by the requirement that they be performed. And that's really what the judge is concluding here. And he's absolutely right in that conclusion in my submission. My learned friend says, well, that can't be right, because if you read Chucker over in that way, it means it's superfluous because it adds nothing to the contractual position anyway, because obviously if there's a contractual obligation to repay, then why can't you just rely on the contract? And so on that basis, he says, well, Chucker over must add something to that. My submission is that that complaint has little force. Firstly, because given what Lord Mance says at paragraph 44 about the unusual and exceptional situations in which the discretion will be exercised, it's perhaps unsurprising that the case is going to have little impact. But in any case, as I've said, all of the cases focus on disallowing interest when a tender has been made and when the tendered funds have been set aside. That's when equity intervenes, even if the refusal to accept the tender is not a breach of contract. And your lordships will recall that Lord Mance refers to a much earlier Privy Council decision, which holds that refusal to accept monies that are tendered doesn't constitute a breach of contract. And Lord Mance questioned that, whether that was really right, but didn't decide the point. But the point is, of course, that even if one starts from the principle that a refusal of a valid tender is not a breach of contract, well, equity there is adding something to the contractual position. But even if it's wrong, even if it is a breach of contract, equity still adds something, because the way in which equity's intervention works is different in nature from a contractual remedy. What the cases on mortgage redemption show is that equity intervenes effectively to prevent enforcement of an otherwise entirely valid contractual term. That's not the sort of remedy that one gets under the law of contract at all. So equity adds something in terms of the scope and nature of the relief, or the nature of the relief, even if it only arises against the context of performance of the contractual terms.
We are, in this sense, dealing with a slightly unusual situation. In the Paradigm case, the legal date for payment has gone by, and the borrower is relying on his equity of redemption in order to redeem the loan. We, of course, by contrast, are dealing with offers made before the repayment date.
Yes.
I don't know to the extent to which that makes a difference. I mean, to go back to an example that my Lord Justice Newey posited yesterday, a lender has agreed to lend at X% interest, and now you could, if you wanted to, refinance at X minus 1% interest.
Yes.
Is the lender entitled to say, no, contract was that you would repay me in a year's time at X%. I'm not willing to take the money before the repayment date.
Well, I think if the contract, it depends on whether or not the contract permits early repayment. If the contract expressly prohibits early repayment,
it probably wouldn't, would it?
Well, I don't know. Some contracts do.
Right.
Some contracts prohibit it subject to, or allow it subject to payment of some sort of compensation. It varies. But if the contract were to prohibit it, then I think it would have to stand as prohibited on that basis. That was the agreement. But it does depend on the terms of the contract.
That makes sense, but what if the contract is signed?
Well, then one would have to address the question as to whether by implication it was permitted.
I mean, suppose you have a contract where it's perfectly clear that you're entitled to redeem when you want.
Yes.
And the lender has actually entered into a contract under which he's getting a very advantageous rate of interest. And the borrower, interest rates having come down,
Yes.
says, I would like to repay so I can get a better deal. But obviously, the borrower can't do that without refinancing.
Yes.
he gets an offer from an alternative lender for a much lower rate of interest. The money will be available when the existing charge is discharged, but the lender wants to hang on to the advantageous rate of interest. And we might add on, the new lender makes a time-limited offer, as
Yes.
lenders will.
Yes.
So the existing lender is uncooperative. What's the position then?
Well, I think if the existing lender is uncooperative, one then has to look at contractual duties. I mean, there are various authorities suggesting that a lender in that sort of situation has a contractual obligation to be cooperative. And in that case, there might therefore be a contractual remedy. So I wouldn't suggest that in that sort of situation, there's no remedy to the borrower at all. But that's a different question from asking whether this particular remedy is available. If the remedy is dependent on tender, then by definition, it can't be available in that situation unless and until a tender arises. But there may be other remedies. And of course, the way this case was argued before the judge primarily emphasised contractual arguments. And they were unsuccessful, and there's no appeal against that. But that was the starting point. But one has to remember, when one is looking at these issues, that we're not looking at, although this appeal is only about the equitable point, when one looks at lending generally, of course, one has to overlay all of this with various contractual obligations. And those will provide a remedy in appropriate cases.
Yeah.
My learned friend's second argument is to say, well, the judge ought to have found that LCL was at fault in refusing to accept what was offered because it was pressing for default interest when it wasn't entitled to it. And it knew the underlying facts. And one just needs to be clear as to quite what the findings were and what was known by LCL. The judge found that Mr. Stylianides knew that the inspection was essentially a sham. And he attributed that knowledge to LCL for the purposes of the argument on waiver. I should just emphasise, because my learned friend slightly portrays this as LCL almost trying to pull the wool over the appellant's eyes in this sort of particular context. The judge also found that the appellant's agent, Mr. Andreas Liandaris, and Houssein also had the same knowledge. So this was knowledge on both sides about the nature of this inspection. It wasn't a one-sided attempt to mislead the appellants by LCL. It's more a case of LCL being misled by its own employee in conjunction with the appellant's agents. But he did find that for the purposes of the argument on waiver, Mr. Stylianides' knowledge was attributable to LCL. There was no finding that Mr. Stylianides' knowledge could be attributed to LCL for any other purpose. And indeed, there was unchallenged evidence from Mr. Theophanous that Mr. Stylianides had no involvement in any of these negotiations or in the litigation in any way, other than as a witness.
Well, sorry, can you explain that to me? I mean, I take your point that the finding is to attributions made in a specific context, and of course, any question of attribution will depend upon the purpose for which one is seeking to attribute. But nevertheless, when it's a question of knowledge, it seems a little hard to say the knowledge is attributed only for one purpose and not for another. You either know something or you don't know something.
Well, but because of course when one looks at the individuals behind LCL who were dealing with the litigation, they didn't know any of this. In fact,
well, to be sure,
but the purpose.
One is talking about attribution of knowledge to a corporate entity.
Yes. Well, I accept that, Milan, but my submission is that one has to, as your lordship says, look at the purpose. And something that's attributable for one purpose isn't necessarily attributable for another. And I make the point there's no finding on that at all. But perhaps the more significant point is that there's no finding, nor even an allegation, that LCL knew that the consequence of that knowledge was that he had no claim to default interest. In other words, it knew the factual basis for what was eventually the finding of waiver, but there's no allegation or finding that LCL knew that the legal consequence of its knowledge about the nature of that inspection was such that it had waived its rights to insist on this non-residence requirement.
Is such knowledge necessary?
Well, yes, because
So I mean, sometimes knowledge is relevant. I'm thinking of Payman and Lanjani in that kind of case. You've got to know you've got alternative rights. And sometimes that sort of knowledge is not. In the context of forfeiture of leases, for instance, if you accept rent, it has a consequence, whether
Yes.
you know what the consequence is or not.
But the way my learned friend put it yesterday, I think it was put this way for the first time yesterday, was the suggestion that LCL couldn't have advanced its claim to default interest in good faith because it knew of the facts that ultimately defeated its claim. And that simply cannot be right. I mean, one often has situations, firstly, there's no finding to that effect at all. It wasn't alleged at the trial, no finding to that effect in any way, shape or form. But also it is not at all uncommon for parties to litigate in circumstances where there's no dispute of fact at all. Everyone knows all of the facts, but there's a dispute as to the legal consequences of those facts. And the fact that when one party loses, you can't say, well, they're litigating in bad faith because they've known all along what the relevant facts are. It simply doesn't follow. The mere fact that you're aware of the facts that give rise then to a legal argument in circumstances where you're not actually aware of what the consequences of those facts are, legally speaking, and what the result is going to be when eventually this all comes to trial and is considered by the judge.
Well,
That's
I think
different from
perhaps
saying
you
that
can
litigating.
perhaps you may analyse it this way. LCL may not have known what the consequences of the attributed knowledge were, but those consequences nonetheless ensued.
Yes.
The breach was waived. But it doesn't follow from that that their stance was in bad faith.
No.
I wonder there whether the identity of the personal persons responsible for the litigation actually matters.
Well,
I mean, those individuals are deciding to pursue the litigation on behalf of the company
yes.
in circumstances where they do not subjectively have the knowledge, which is why they're not dishonest and there's no bad faith, potentially.
My Lord, yes. And I should emphasise that Mr. Theophanous, in his witness statement for the remitted trial, paragraph 31 at page 416 of the supplemental bundle, he says in terms that he didn't know about any of this, senior management of LCL didn't know about any of this, and that so therefore they in good faith believed that there was an event of default and that there was an entitlement to default interest. And he says neither Mr. Stylianides nor Mr. Leondaris had any involvement in London Credit's consideration of settlement or repayment offers from the claimants or the making of London Credit's own offers. So the facts, and that paragraph of Mr. Theophanous' witness statement wasn't challenged when he was cross-examined. So the fact that the relevant people behind LCL driving all of these responses to these offers and the way the litigation was conducted, they didn't know about this at all. And so in that context, if one asks if an offer had been accepted and a settlement thereby concluded, it would have been a valid and effective settlement. One couldn't say it was an ineffective settlement because LCL was acting in bad faith. The reason that a deal wasn't reached, as the judge found, was that the appellants simply weren't willing or able to go the last step to conclude an agreement. And in any event, none of this converts what the appellants did into a tender. So in my submission, this point doesn't assist the appellants. I can then perhaps turn on to the question of how the judge dealt with the tenders. And perhaps in that context, turn back to the first of the offers, which is in the supplemental bundle, And in fact, I think the first offer your lordships were taken to yesterday was at page 226, behind tab 30. Perhaps I could invite, sorry, behind tab 32, but perhaps I could invite you just to turn to page 224, behind tab 30.
And the supplemental one.
Yes, my lord.
Yeah. I don't in fact have tabs, but it doesn't matter as long as you give me the page.
I'm sorry, I'm as you can see, working 224. Working electronically, so I've got don't.
You haven't got tabs either.
Don't. I'm afraid. Yeah, I was unaware of that. I'm afraid, but I won't bother referring to tabs in this bundle. So at 224, we have an email from HCA, the appellant solicitors, sent on the 15th of March, the day before the first offer. And we see in the middle paragraph between the two hole punch echoes on the photocopy. In addition, our client's refinancing of the 3 buy-to-let properties will be completed in the next 3 to 4 weeks, releasing at least 1.2 million. And our client has now received an offer of bridging finance, which will provide at least 650,000 to our client, making a total available of 1.85 million. Entirely without prejudice to our client's assertion that default interest claimed is a penalty, what our client would like to do, if possible, is to discharge the charges affecting all of the properties in return for a payment which represents a discount in the early repayment of the facility. On a without prejudice basis, our client will also be prepared to discuss a sensible default rate. And then the final paragraph is, can you take your client's instructions? So what this is doing is flagging the idea that they wanted to achieve some sort of compromise, outlining the sort of terms that they're considering and asking for LCL's views. And the next page, page 225, there's then a question back from Gunnar Cook.
Sorry, can I just understand what's being asked? They want to discharge the charges in return for a payment which represents a discount in the early repayment of the facility. Does that mean that they want credit for interest, the rolled up interest, or part of the rolled up interest, which would not have accrued?
Well, it's not.
Is that what it means?
It's not entirely clear. But what it's not doing is offering a precise calculation.
Yeah.
It's not saying we propose to do all this on the 15th of April or whatever the date may be, and the interest due to that date will be this figure. Therefore, that's what we're going to pay. It's saying, well, we've got 1.85 million. We'd look to sort of negotiate a payment based on that, and then something more representing a compromise for default interest. So this is essentially a settlement figure. And if this develops into a concluded agreement along these lines, what one would have is essentially a bargain that whatever the final number was would be paid. And that then would be the binding agreement, and that would be the basis on which the parties had to proceed. And it would then be neither here nor there what the settlement or the facility letter said, because you're putting aside the precise calculations under the settlement, the facility letter, and just saying, well, let's just do a deal based on this number. So that's really what's being canvassed here. And then at 225, the response to this is asking whether it's right to say that the 3 Downhills Way properties will be refinanced for the 1.2 million and a lump sum made available for payment to LCL by close of business on the 14th of April. I'm instructed that should the refinancing proceed at a satisfactory pace, then London Credit may be willing to consider its position with regards to default interest at the point the refinancing is to complete. So it's not an absolute no at that stage. It's well, is this what you mean? And if so, we can talk about it. We then, against that context, get the offer at 226, which your lordships were taken to yesterday. This, of course, is why it begins saying, to be absolutely clear, this is what our offer is, because it's against the context of that exchange of correspondence. And you've already seen what is being offered. My learned friend, of course, emphasised points 1 and 2, saying there 1.85 million is being offered by the middle of April. But one also has to take account of points 3 and 4. Because in return for the 1.85 million, they want a discharge of all of the securities, but they also want agreement as to a concessionary default interest, but which my clients will pay. So in other words, they're not simply offering to pay 1.85 million. They're willing to pay 1.85 million plus something more to be agreed, but that's something more is going to be paid on an unsecured basis because all the securities are discharged on payment of the 1.85 million. And then in point 4, in return, there's a standstill on the actions of the receivers in the meantime. There is, of course, fairly obviously, no suggestion at all that any money is available on the 16th of March. They're not coming with an attempt to pay money. They're coming with an offer to do a deal. And as the last paragraph makes clear, and as I think your Lordship saw yesterday, at this stage, they hadn't even accepted what they describe as an offer on the bridging finance. So the £650,000, they're saying in the last paragraph they haven't accepted that bridging finance offer. But in fact, your Lordships were taken to this yesterday, when one sees what that offer is, it's in fact just a term sheet. So,
Sorry, one of them is just a term sheet. Does this only relate to that, or does it relate to Kent Reliance,
No,
which is more than a term sheet?
well, it's referring to the bridging finance offer. So I understand, and the Kent Reliance was a longer term lending proposal. So I understand this reference to the bridging finance offer to be a reference to the bridging finance, 650,000, which was to come from Overture Capital. And as I say, there we just had a term sheet. The lender wasn't bound to lend. And indeed, there's no evidence that the lender had actually made an offer that was capable of acceptance, in the sense of an offer that could be accepted giving rise to a binding contract to lend. We just have a proposal for the terms, and the lender was free to pull out at any time. So that, on no view, is the £650,000 available. And there's no certainty even that it will be available by the middle of April.
Yeah.
And it concludes, the final 3 or 4 lines, says now that there seems to be some possibility of an agreement. Again, that's that indicates that this is not the appellants seeking to make payment on the basis of the existing contractual terms. So the contract says we owe you this, therefore that's what we're prepared to pay. It is an offer to make some payment in the future, subject to conditions, on the basis essentially of doing a deal. A learned friend says, well, in the context of an intent that the loan would be repaid by refinancing, then what's proposed here is sufficiently immediate to constitute a tender. That's the way he puts his argument. And that can't be right. And whatever my learned friend says about the date from which interest liability ceases, it is this document that he relies upon as his tender. If money is tendered and accepted, then of course the debt is immediately discharged. If this proposal had been accepted, the debt wouldn't have been discharged, not by virtue of the acceptance. It would only have been discharged later if the appellants had in fact made the payments that they were proposing to make in this offer. And the fact that the payments are being funded by refinancing doesn't alter that either way, in my suspicion. It makes no difference at all.
If one simply focuses on that point, then that puts the person in the ordinary sort of situation we were talking about earlier in a very difficult position, because they can't provide the money with the letter. They have to say, look, we have an offer of refinancing, we've accepted it, the money is going to be available on completion, that's good enough.
Well, Lord, that's right, but of course in that sort of situation, it all works in stages. One asks for a redemption figure, one asks for an agreement that the mortgage will be released upon repayment. generally speaking, solicitors are involved on both sides. You have an undertaking by the original lender to release the charge upon payment, and that's all set up, and then the money is tendered. And that's the process. And it's when one gets to the point of tender, if that's then refused, then we see the consequences that flow from that.
So hang on, what is the tender in that situation?
Well, the tender is when you're actually saying we've got the money, we're
Well, you're not going to have the money
well
until
the borrower.
It's going to be a simultaneous.
Well, no. The borrower will generally speaking have the right to call on the money, the right to draw on the loan.
Yes.
And once one reaches that point, and often in practice, actually, the new lender will pay the money to the solicitors to hold on trust effectively. So one does reach a point where the borrower is in a position to call on the money, even if it's not in his own account, even if it's held subject to conditions pending release of the security. The mortgage or the new borrower is in as good a position as he would be if he had the bag of money. And that's what we see in Shearer and Spring Capital. It's in as good a position. And that once one reaches that point, you are in as good a position. And yes, if then the old lender said, no, I don't want your money, sorry, for whatever reason, that would be a refusal of a tender. But if at the earlier stage, for example, when there's a request for a redemption figure, the old lender says, no, I'm not going to tell you that. Well, then one's into the territory of contractual obligations to cooperate and that sort of issue, rather than the consequences of a tender failure. That, in my submission, is how one addresses that scenario that your lordship asked about. My own friend also tries to make something of what he describes as a concession that he says I made in the course of closing submissions, and which the judge refers to, and which he says the judge goes behind. And just to deal with that, in the course of closing submissions, the judge asked me if this was an offer that could be accepted such that it gave rise to a contract. In other words, was it an offer capable of acceptance and giving rise to a binding contractual obligation between the parties? And my answer to that was that it was. If the response to this had been an unequivocal yes, it's agreed, then in principle, whilst I appreciate that some of the terms are a little vague, in principle, I think that could be a binding contractual obligation. My own friend says that's a concession, but it really wasn't, because in truth, it doesn't actually help the appellants at all. The fact that it's an offer to agree revised terms and to make payment on a basis which, if accepted, would result in a revised set of contractual obligations really just demonstrates that it's not a simple tender seeking to discharge the existing obligations, it's a settlement proposal. That's why, in a sense, why it would require acceptance in the contractual sense. And if I could just invite your lordships to turn back to the judgment.
Sorry, I'm not entirely following this. Everybody knew, as I understand it, that 1.85 million would be enough to repay the principal lent and at least a part of the rolled up interest for the first year. The dispute was over the default rate interest, which
Yes.
LCL claimed to be entitled to charge, and the Husseins and SEC, if that's how you pronounce it, check, disputed.
Yes.
So if you had accepted the proposals made on the 16th of March, which include a concessionary default interest rate to be agreed, you have not settled the dispute about the default rate because you've still got to agree the concessionary default rate.
Well, I accept that's right, my lord. It may be that I was wrong to answer the judge's question in the way that I did. But in a sense, it doesn't matter.
Yeah.
Let's assume that, I mean, if one assumes that one can accept an unequivocal yes to this email would result in a binding contract, and yes, there are then bits still to be agreed, I accept that, and there's all sorts of complications regarding that. No doubt about that, but assuming it was a binding contract, then that doesn't help the appellants one little bit. As I say, it's inconsistent with their notion that this is a tender. And I was just going to take the court to the way in which the judge deals with this point. It's on page 100 of the core bundle. Because my learned friend says, well, the judge goes behind my concession. And it's paragraph 68. And in the middle of that paragraph, he says, Mr. Wheeler conceded that the first communication on which the claimants rely was a contractual offer, and that the other communications were probably also contractual offers. He then says, for my part, I would think that many solicitors would be somewhat surprised by that. Typically, the emails, exchanges and discussions work out the commercial terms of the deal, but it would only be finally agreed in a more formal settlement agreement. Well, that's right, of course, as a matter of practice. And it's what one sees happens in the exchanges following this email as a matter of practice. But that comment by the judge isn't going behind the concession that I made. He's simply commenting on what was likely to happen in practical terms. I was asked a very black and white legal question. Is it an offer in the contractual sense capable of acceptance, giving rise to a legally binding contract? To which I said the answer was yes, rightly or wrongly. That's what I said. But the fact that in practice one would expect something more to be done, well, of course that's right, but that's addressing a different point. It's not going behind what I said. It's just saying, well, in practice, this is actually likely to be done in a different way.
I certainly wonder whether he is going behind what you said, but given the last sentence,
Well,
maybe that doesn't matter.
I was just going on to get to the last sentence where he says this is irrelevant, because even if they are contractual offers, it's not an offer for payment. Now, that's plainly right. And that's really what matters here in my submission. None of this point goes anywhere. And my learned friends get very excited about a concession that I'd supposedly made, but it really doesn't help them at all in my submission. And if one, while we're looking at the judgment, goes on to paragraph 71 on page 103, one sees there the judge's conclusion on this first offer. It says it's self-evident it's not a tender nor an offer of payment, because the funds are not immediately available, and that in my submission is plainly right.
So what did he mean in that first sentence? I mean, supposing, does he mean they're not immediately available, they're not available on the 16th of March? Or does he mean
Yes.
that they won't be available at the point at which the completion would happen?
Well, they're certainly not immediately available on the 16th of March.
Is the judge regarding that as fatal?
Well, I think it is fatal to regarding that 16th of March email as a tender. It's not tendering funds. But it's also, if one reads it the other way, the £650,000 wasn't definitively available at all either. So in both senses, as far as that 650,000 is concerned, there are difficulties. So that's the first offer. Perhaps I can then go back to the second offer in the supplemental bundle at page 233.
Just before you do, I mean, you've focused particularly on the overture document.
Yes.
Is that the basis of any of the judge's decision?
Well, it is. The judge deals with that, I think, at paragraph 80, where he addresses the question of as to how difficult it would be to move from term sheet to loan. And there was disagreement between the parties as to that. And the judge's conclusion on all of that is that there remained a considerable degree of uncertainty.
Yes.
And the judge emphasises various points, but of course one has to acknowledge that overture was not in any way bound.
He makes a point about the personal guarantee from Houssein.
Yes. As to which, as was discussed yesterday, there's no evidence at all. So in the light of that, if I can go back to the second offer that's relied on.
I think we're going to need to pick up the pace a little bit, Mr. Wheeler.
Lord, yes.
We've still got penalty to deal with.
Yes, certainly.
Mr. Cowan must have time to reply.
Yes, well, I recognise that. I think I am on track actually,
Right.
but I recognise that, Lord. And I think I can take this quite quickly because it doesn't add much and the same points really apply. But actually, when one looks at the offer on 233, one sees that we've almost gone backwards in the sense that the 1.2 million is now no longer a date. No time, we've got partial redemption, which isn't permitted by the contract. And we've then got a whole series of conditions in relation to how and these are in paragraph 4 on page 234, as to how the outstanding dispute in relation to default interest will be dealt with. So it's quite plainly not a payment to make, an attempt to make payment. It's a proposal for future part payment and for resolution of the balance of the dispute subject to a raft of conditions. And it is important to understand that LCL didn't simply say no to this. Firstly, they asked for the term the offer, the overture offer, which produced the term sheet. And then at 248, they made a counter offer. This is a counter offer dated the 30th of March. And at the bottom of page 250, we see the heading resolution. It said it's in everyone's interest to bring a resolution to this matter. And one sees the counter offer at point 1, on or before 14th of April, LCL receives 1.85 million exchanged for release of its security over the 3 Downhills Ways properties and 71 Hamilton Road. Well, that's essentially what the appellants have been proposing. And then in point 2, it said, at the end of the first paragraph under point 2, strictly on the conditions that the 1.85 million is repaid and the outstanding debt is paid before the expiry of the term of the loan, LCL is willing to discount the default interest payable and to cap its remaining outstanding debt to 350,000. So whereas the initial proposal was the 1.85 million plus a figure for default interest to be agreed, this counteroffer is essentially mirroring that and saying, yes, the 1.85 million, we're happy with that as you proposed. And as far as the default interest, you've said a figure to be agreed, but we're proposing 350,000. So it's not, as my learned friend puts it, simple rejection on the part of the appellants. LCL followed through and tried to refine the proposal and suggest something that it thought should be acceptable. And we then have, in that context, the offer at 253, which is the offer of the 7th of April, where the proposals start at paragraph 4 at the bottom of that page and run on to the top of the next page. And we see here, point 1, the 1.85 million, it slipped a bit. It's the 21st of April by this stage, and no one took an issue with that, but they were still at 1.85 million by mid-April. Then 2, discharge of the securities over the Downhills Way properties and 71 Hamilton Road. Point 3, discharge the receiverships. And then point 4, on the second line, on receipt of the probate, Mrs. Houssein will complete the refinancing of the other 2 Downhill Way properties as quickly as possible and pay LCL with a sum of 350,000. So in other words, the £350,000 that LCL suggested as the sum in respect of default interest is essentially agreed by the appellants. We've reached the point at this stage where both sides are saying that 2.2 million will be enough to settle this dispute. But the appellants say that that offer of £350,000 is subject to 2 conditions. Firstly, the lenders agreeing to extend their mortgage offers. And secondly, compliance is conditional upon Mrs. Houssein receiving independent financial advice from an advisor who can speak Turkish. And that was the stumbling block. And that was what caused the difficulty, because when at 255, LCL reverts to say, essentially, this is all fine, but that £350,000 has to be paid on or before the 9th of August. That then wasn't something the appellants could accept, and one that has an extraordinary sequence of correspondence. And I think for the purposes of time, I won't take the court through it, but one has a sequence of correspondence throughout April in which LCL presses for a response to their offer of the 30th of March. They make repeated offers of their willingness to accept £2.2 million, and there's various configurations of the way in which that offer is put, various different permutations in terms of timing and amounts at different points and how it can be done. And all of them, well, none of them are accepted by the appellants. And one reaches the conclusion firstly at page 277, where HCA say in their final paragraph, in relation to LCL's attempts to settle, all we can say that is every offer is made conditional upon conditions which are incapable of performance in a timely fashion. So we've got a case where the appellants are now contending that they have tendered the sum of 2.2 million to LCL, and LCL refusing to accept it. But in fact, LCL are saying they're perfectly happy to accept 2.2 million. And the complaint is, well, we can't do this, essentially, is the complaint. And there are conditions as to timing. And you've seen they seek payment, the final part of the sum that was offered by the 9th of August. And it said, well, this is conditional and we can't meet these conditions. So that's wholly inconsistent with the suggestion that the 2.2 million was actually tendered. And where this ends up is at 282. We have a revised offer from the appellants, now down, centres on a WP savers to cost basis, now at £2 million.
Are we supposed to be looking at this?
Well, it's important context, my lord, both for the judge's findings and for the question of the equitable discretion. And this is one of the offers that was relied upon at the remitted trial. And
so you're saying that the WP status was waived?
By the point of the remitted trial, certainly, yes, it was.
Right.
But the offer, effectively, the offer for 2.2 million is now effectively withdrawn. They're down to 2 million at this point. The 1.2 million relatively soon, and the 800,000 by the 9th of August. And that's not accepted. LCL stick at 2.2 million. And at 284, we have the final part of this whole chain of correspondence, where the appellants say, my instructions are that my clients will take their chances with the litigation. And in the final paragraph, it's a pity that settlement could not be achieved. For the avoidance of doubt, my clients offer to settle, and firstly, that's how they see it, an offer to settle, not a tender, but it's no longer open for acceptance. So however one characterises it, it ceased to be there and ceased to be available on the 12th of May. So far from keeping the tender open and keeping the money available, they expressly withdrew it. And they said they would take their chances with the litigation. That litigation was commenced, I think the claim form was issued shortly before this email was sent, at the end of April. But when these proceedings were commenced, there was all sorts of grounds on which the appellants challenged LCL's right to recover interest on the loan. Tender was not mentioned at all. Absolutely no suggestion in any way, shape or form that tender had been made. And the judge, in the light of that, paragraph 100 of his judgment on page 110, was absolutely right. He concluded that all of this really was seen at the time as a settlement negotiation, or a series of settlement negotiations. They weren't tendering payment. They didn't even think they were tendering payment, the judge concludes.
Sorry, which paragraph?
100, my lord, on page 110.
Yeah.
And in my submission, he's absolutely right about that. And at page 102, paragraph 69(8), one has the very strongly worded criticism of the appellant's conduct in relation to all of this, which is entirely justified in my submission.
Sorry, where are we?
69(8), my lord, on page 102 of the core. The very bottom starts at bottom of 102 and runs on. And has a strongly worded criticism of the appellant's conduct.
Yeah.
No finding of wrongdoing on the part of LCL at all. So that then takes me on to the question of default interest and ground 3. And of course, there's no argument here that the judge made any error of law when addressing this issue. There was some debate yesterday as to the precise nature of the complaint that was being raised, and perhaps I could just take your lordships to page 15 of the core, behind tab 1, where one sees the grounds of appeal. And one sees it's very, very clearly worded that the judge erred in determining that the default rate under the facility was not a penalty at common law. It then goes on to add that he relied upon evidence and academic articles without giving the appellant the opportunity to address him on the relevance of that evidence. Well, or the academic articles. But just on the question of academic articles, very briefly, I've dealt with that in my skeleton. My learned friend didn't pursue it in his oral submissions. Don't think I need to say anything more about them because there's no serious suggestion that they add anything of real significance to the judge's reasoning or lead him into any substantive error at all. It's obviously wrong in my submission to say that the appellants didn't have the opportunity to comment, to address the judge on the evidence, because they had the entirely normal opportunity in closing submissions to address the judge on the evidence. And indeed, in my learned friend's skeleton argument, paragraph 55, the way the case is put is again very clear. The judge erroneously applied the law to the facts of the case. Had he done so correctly, the
Sorry,
finding
where are
would have
you?
been
50?
55, my lord, on page 34 of the court.
Yeah.
Had the judge applied the law correctly to the facts of the case, the result would have been a finding that the default rate was a penalty. So that's very much the emphasis of the way that it was put. The judge got it wrong, effectively, in his assessment of what the witnesses said and the assessment of the evidence. And that's why, in my skeleton argument, I cited the decision in Sprint Room, which is obviously a very well-known authority on the circumstances in which this court will interfere with a trial judge's decision on such matters. Given the way the matter's developed and given how well-known that case is, I don't propose to go to it unless it would particularly assist. What I do want to do, if I may, is put into context the way this issue, this point arose, the point about which my learned friend now complains. Because if I could ask your lordships to go to the judgment, paragraph 132, which is page 116 of the core bundle. One sees there the argument that my learned friend made before the judge, which ultimately was accepted by the judge, was that you don't just look at LCL's legitimate interest in repayment if it was extortionate or unconscionable, or if it's the legitimate interest underpinning any primary obligation. The default rate as a whole would be unenforceable. And that's the argument the judge then accepted. And once he accepted that it's necessary to go through this process, he then had to identify the various legitimate interests that were underpinning the primary obligations. That's inherent in the acceptance of the argument. But the problem was the evidence wasn't directed to that exercise, and the appellants didn't actually advance any case as to what the various legitimate interests were, or why they said the default rate was extortionate by reference to those interests. And So the judge did identify those interests, and having identified them, what he had to do, and I think the appellant's position as to what he should do, was to assess the default rate against each of those interests. Now, having invited the judge to follow that course, it's very difficult in my submission for the appellants now to complain that it was unfair of the judge to do so. It's taking precisely the course that he was asked to take by the appellants. And the judge himself identifies the difficulty that he faced. And one sees this at page paragraph 270 on page 148. Where he says the immediate difficulty here arises with a mismatch between the way the law approaches this question and the way that the expert evidence was presented at trial, because the expert evidence didn't seek to do this at all. It says at 271, the experts presented the issue holistically, looking at what rates were typical in the market. And at 273, the judge says, well, against that backdrop, it seems to me that the proper way to address this question is to engage with the expert's evidence in the terms that it was given, which is essentially to ask whether a 4% rate would ever not be extortionate. If in some cases it would not be extortionate, the question then turns to the strengths of the interests I have identified. Now, that's as I say, the way the case was argued. The judge was put into the position then of having to grapple with the difficulty between that analysis of the law and the way the evidence went forward. That cannot be, in my submission, a source of procedural unfairness. And if, against that background, if I can just invite the court to turn back to the evidence of Mr. Griffiths, which is in the supplemental bundle, and the relevant passage starts at page 95. Page 95. Yeah. And so one sees, he introduces at 3.55 at the bottom of 95. It says the calculation he's looking at essentially is addressing whether refinancing is likely to be achievable. And that's obviously the key question. From that perspective, it doesn't actually particularly matter that LCR undertook this calculation. What the judge is required to do is look at the credit risk interest from an objective perspective to see if the default rate is extortionate by reference to it. And the credit risk interest is essentially LCR's interest in preserving the appellant's creditworthiness so that refinancing can be achieved and the loan repaid. So one needs to look at it from the objective question of what would that hypothetical alternative lender do? And at 3.57, Mr. Griffiths is very clear. He says lenders set criteria for both LTV and interest cover, and both must be satisfied for a loan to be received. To proceed, this is simply because a loan proposal may well have a low LTV, but unless there is sufficient income to service interest, then the chances of default are very high. So Mr. Griffiths does address here the interplay between the two different factors. And he's very clear that you need to satisfy the criteria for both. A low LTV is no good and no help unless there is sufficient income to service the interest on the loan. So he then looks at LCL's calculation, and the lordships were taken to that already. There's two elements to it. There's the 5.5%, which is said to be common, and then there's the 145%. Now here, on the interest cover ratio, at 3.64, the top of page 97, Mr. Griffiths says interest cover requirements varied between 125 and 160%, although the majority were in the range of 125 to 145. It says, in my opinion, the use of 145 as a basis of calculation is at the upper end of the range that could be used and can be regarded almost as a worst case. Now, the judge takes slight issue with that, in that he says, well, it's not really worst case if some lenders go up to 160, but it is plainly the top end of what Mr. Griffiths describes as where the majority of lenders are sat. Then at 3.67, we have the table that's reproduced in the judgment.
Yeah.
I think in answer to the question about an error in the table that was raised yesterday, on the second part of the table, the Downhill's properties rental income is given as 111,400. I think that is the correct figure because the maths makes sense.
I don't suppose it matters at all, but the figures in the judge's table are wrong.
There's a typographical error
Yes.
for this figure,
Yes.
but the 111,400 is the correct figure. Where there is, and the error that the judge points out in his judgment is the reference in the fifth row of the table, in the first column, interest cost is 145,000 divided by the interest cover ratio. Well, that's correct for the top half of the table, but for the bottom of the half, that should say 111,400. But that's the error that I think the judge points out. But I don't think anything turns on any of that. But my learned friend's complaint is that the bottom half of the table was focused on by the judge, not the top half of the table. But the judge applied an objective test when he was looking at this. He was asking, what would a hypothetical reasonable alternative lender do? And of course, it's common ground that there was no rental income at all from 71 Hamilton Road.
Well, what the judge says about that is at paragraph 324 of his judgment. He says, I think he, that is Mr. Griffiths, was right to assume that only the Downhill Ways property were income generating. And then he makes this finding. LCL had been told 71 Hamilton Road was still undergoing renovation work, following which the Husseins were to move back in.
Yes.
Sorry, I didn't catch the paragraph reference.
324, page 160. And I think he repeats that finding somewhere else in the judgment.
Yes. Well, that explains why LCL did the calculation that they did.
Well, did they though? Because Mr. Griffith's interpretation of the underwriting document seems, which we've got at supplementary page 95, seems to talk about a rental income 145.200-12/12 months, and that seems to be 145,000.
No,
Is that right? Maybe it isn't.
yes, it's perhaps easier to look at it at 3.59, where he breaks the calculation down.
Yeah.
And he is there looking at annual market rent at 145,000.
Yes. That's
That's
seems
what
to
LCL
be.
did.
That's LCL. But then the judge says, as I said, at 324, that LCL had been told that 71 was still undergoing renovation work, following which the Husseins were to move back in.
Yes, well, I think the bottom line is that LCL made a mistake in taking account of 71 Hamilton Road's rental income. That was their error in their calculation. But there's nothing turns on that. Nothing turns on that for two reasons. Firstly, what the judge was doing, and one sees this at paragraph 339 of the judgment. It talks about applying realistic assumptions. A reasonable lender in LCL's position in July 2020.
I beg your pardon, where are you now?
339, my lord, and 163.
Right, thank you.
Starting, nor is that analysis limited to judgment debts. Is that the
Yes.
paragraph? Yeah.
And 4 lines down, refinancing of this portfolio is far from straightforward. Applying realistic assumptions. A reasonable lender in LCL's position in July 2020 would, in my view, probably conclude that there was no or almost no margin for error. And of course, a reasonable lender, looking at this, couldn't be assumed to make LCL's mistake of taking account of non-existent rental income from 71 Hamilton Road. A reasonable lender would look at what the rental income was actually achievable. And one can perhaps look at that from the other end of the telescope. Supposing LCL had made a different mistake, supposing LCL had wrongly ignored some rental income that was in fact available, supposing their calculation suggested there was a much narrow margin of affordability than was really the case, but nonetheless they went ahead and advanced a loan, doing it on the basis of a very narrow margin and quite high risk, and set a default rate accordingly. If one then tested that, one wouldn't test that against LCL's erroneous calculation. One would look at the correct figures one would take account of the rental income that LCL mistakenly ignored. And we'll say, well, actually, the true position is that there's lots of rental income, and you have to look at that. And that's what an objective lender would do. And we look at the calculations against that context. So plainly, when one looks at it from that perspective, it's right that LCL's mistake can't have any bearing on this. It must be that one looks at the position of what the refinancing lender would do.
Can you help me? Because what I'm struggling with on this aspect of the case, and maybe the point you've just been making is germane to, is what's this got to do with justification for 4% interest compounded monthly? Because these seem to be quite fine-grained points as to the level of cover, and that would be relevant, one might have thought, to the question of whether some kind of default interest is reasonable, and of course some level of default interest is reasonable, but that's not the question the judge is faced with, is it? The judge is faced with the question of, does this justify 4% compounded monthly, which is tantamount to 60% per annum?
Well, that's not quite the question, Rob. The question is whether that rate on the evidence is extortionate.
Well, indeed, yes.
And against the context, one has to remember, of having found that there's a presumption, because both sides were legally advised and properly represented, both sides agreed to this, there's a presumption that both parties were well in a good position to determine what was a reasonable consequence of default. So that's the starting point. And the question is then, can one displace the presumption? And what one has to look at from this perspective, well, this loan was always going to be repaid by refinancing. Refinancing is only going to be possible, obviously, if there's a new lender willing to come in and lend. That's why it's relevant to look at the view a new lender is likely to take. And that's why when one looks at Mr. Griffith's figures, when one looks at the table, whether it's in Mr. Griffith's report or in the judgment at 319, one has to remember Mr. Griffiths is approaching this on the basis that to repay the loan, you're going to need 1,618,000. That's the figure you've got to hit to be able to refinance. And in his table, the only way you
that
get
assumes no default.
Well, it's not clear. Well, it assumes no default interest, yes.
Yeah.
It's not quite clear where he gets that figure from, because he's effectively discounting all of the 1% in all of the standard interest and all of the fees in producing that figure for refinancing. So I'm not entirely sure how he comes up with it, but at the original trial it was never challenged. And so the judge effectively just accepted this figure from Mr. Griffith's report and worked on that basis. So we have that figure of 1,618,000. And on Mr. Griffith's table, one only gets a loan in that sum or more available based on the Downhill's Way properties if the lender is willing to work on the basis of interest cover of as low as 125%.
Well, to be sure, but this is why I'm struggling, because this is all about what do you need to do to refinance at term,
Yes.
assuming no default interest. But I struggle to understand what this has got to do with justification for 4% compounded monthly.
My lord, the point is that the interest that's been protected, the credit risk interest, is essentially the ongoing creditworthiness of the appellants. And the point is, if that, for example, a judgment on another debt is entered against the appellants during the term of this loan, that would be one of the events of default protected by this interest. The difficulty that will create is then when you come to refinance, the new lender will look at that judgment against the appellants, and that will influence the new lender's, well, their willingness to lend at all and the terms on which they will lend. And so the point is that when one looks at just the position on a straightforward analysis, Downhill's Way properties, do they generate enough income?
I'm sorry, I'm obviously failing myself to make myself clear, because let's assume that everything you've just said is totally correct. And it may well be. But what's puzzling me at the moment is what's the relevance of it? Because, okay, suppose one looks at this question through the eyes of a new lender. For this purpose, don't we have to ask ourselves this question? Is a new lender going to be willing to pay 4% compounded monthly in the event that there's a default, and therefore default interest is kicking in?
Well, I'm not sure that's quite the question, my lord. The question is, the point is that it all depends on the availability of refinance. If you can't get refinance, the loan is going to default. Therefore, it's critical to LCL that the appellant's creditworthiness is maintained. And the reason that the narrowness of the margin is so important to the judge's conclusion, I think he says at one point, I'm just trying to find it, but he says a miss is as good as a mile.
Yeah, to be sure, I totally get the point.
Yes.
That it's critical that it's going to be refinanced at term. But that's assuming no default.
Yes.
The question is, surely, on the converse assumption that there is going to be a default, and that therefore default interest is going to be payable at 4% compounded monthly, what impact does that have?
Well, no, I don't think that is the question, my lord. I think the question is, when one looks at the legitimate interest that is of LCLs that's been protected by the contract, having regard to that legitimate interest, and the judge is finding this is a very strong legitimate interest in the appellant's creditworthiness being maintained, against that context, can the 4% be said to be extortionate? In circumstances where the experts were agreed that the normal sort of range one would expect for default rates in this sort of loan in the market is 2 to 3%, and that 4%...
Compounded monthly?
Yes, compounded monthly, and that Mr. Griffiths, in his report, as the judge points out, although he's slightly equivocal in the way he puts it, he puts 4% as being sort of the top end of the range.
Is it? I had the same question that my lord just asked. Are the experts agreed that when they're talking about default rates, the rates are compounded monthly?
Oh yes.
Could you just show us that?
Yeah.
Well, there is the joint report,
Right.
which is at page 170.
170.
Yes, 170 of the supplemental bundle. And the relevant part is at page 172. Point box 2. In the middle column, this is what was agreed between the experts. It's agreed that in comparison with the market and when comparing LCL with similar lenders, 3% per month would be more in line.
But that doesn't say compounded monthly.
No, well, it says per month, my lord, and it doesn't say compounded. I think that's obviously right here. But of course, one normally expects banker interest to be compound, and one would have expected if they weren't on all fours, talking about 3% compounded as compared with what's in the contract, 4% compounded, they would have said they were talking about something that was on an entirely different basis. They never do, never any suggestion that that's the issue. So 3% is in line with the market.
So your point is that the experts were agreed that a rate of interest compounded monthly was the norm.
Yes.
That I think Mr. Griffith says he and Mr. Kiriakou hovered around 3%.
Yes.
And that 4% compounded monthly was high but not outside the acceptable range. That's your position.
Yes, my lord, yes. And that's what the judge found. It's reflected in the evidence. And that's why, against the background of the presumption that the parties have agreed this, properly advised, the presumption therefore that they, as it were, know where their own interests lie and are happy to agree this.
So
That's the basis on
we
which
were
it's not
shown that
extortion.
bit in the judgment yesterday, but could you just remind us of where the judge says that? you're absolutely right. I remember Mr. Cowan took us to yesterday, but nevertheless, I would find it helpful just to be reminded.
Sorry, not the point about the presumption.
No, the point about the experts and where they came out on the percentages.
Yes.
I think it's round about 288, 289.
Yes.
If I remember right. So maybe 285.
Yes, it's well, 285 is
I think
well
282.
282
is where it starts, I
really.
think.
There's a passage from 282 dealing with the joint expert statement and what Mr. Griffiths says in his report. So where we have 4% is at best the upper extremity of the band and is outside it, and there's obviously a tension between that which the judge picks up on. We then have the joint statement of experts at 283. And then we have the passages in cross-examination to which the court was taken to yesterday.
Can I just go off on a slight tangent for a moment? We're talking about the prospects of refinancing. I mean, the creditor's ultimate interest, and this I suppose accords with what you were trying to persuade the judge of at trial, is in being paid.
Yes.
This particular interest is only of significance insofar as it reflects on the prospects of being paid.
Yes.
Now, there were two ways in which this could work out from LCL's point of view. There could be a refinancing as was anticipated, or of course, if no refinancing could be achieved, they could sell the properties.
Yes.
So if the loan to value is really good, who cares that much about the ability to fund the interest payments? Where does that feed into all this?
Well, that's not what Mr. Griffiths said, of course. Mr. Griffiths says that the ability to fund the interest payments is critical because no one's going to lend simply on the basis that the security will be fine, but they're not. Inevitably, default is going to occur. But
when you're working out the significance of something happening which could affect the ability to refinance, and therefore how much you might charge as penalty, to use an inappropriate word, do you not have to think about, well, if the worst happens and we can't refinance, actually we're fine because we'll just get the money out of the security?
Well, except that essentially is almost accepting that this all falls into default, and then one has to go through the rather cumbersome process potentially of enforcing the security. It's not a, of course, it's an option. Of course, the security is there for precisely that purpose. But the whole point about this is to protect LCL's interest in the terms being performed. That's what they really want. They don't want the fallback in lieu of performance. They just want performance. And that necessitates, obviously, repayment on time, which in practical terms...
There's a slight flavour in what you've just said, and forgive me if I'm caricaturing it, that the 4% is there to incentivise performance rather than
well, there is an element of
the
that.
need to enforce security.
But there is an element of that, and that's perfectly legitimate. One sees that in Bessie.
So you say incentivisation of performance is not the same as a penalty?
No, it's not. No.
There is a certain artificiality about all this, isn't there? Because LCL would never have gone through this laborious process. In fact, I think at the first trial, Mr. Theophanu said that the default rate was centrally imposed.
It was, yes.
So it had nothing to do with the particular loan or the particular borrowers. So
No.
How does this MacDessie analysis work in that sort of situation?
Because it's an objective test. That's the point. This is the debate we had in the first hearing before the Court of Appeal, where the judge fell into error at the first judgment, was looking at it very much from a subjective basis. The test is an objective one. It's like construing a contract. You do it in that objective way. And so, in a sense, what LCL did or didn't do internally to rationalise this rate to themselves doesn't matter. When one could have posit two lenders in a similar situation with the same default rate, one isn't going to say, well, one's got a really good internal rationalisation for this rate, so therefore it's not a penalty, and the other hasn't got an internal rationalisation. So in the same circumstances, it is a penalty. But it's going to be one or the other, depending on the
I understand that, but then why is all of this evidence about what was actually done by LCO relevant? If it's a purely objective question, then you just look at what the market does, don't you?
But I think that is what the judge is doing here. And that's what he says at 339, when he says he's looking at what the hypothetical alternative lender would do. And that's why I made my submission earlier, that it doesn't matter that LCL made a mistake in their calculation, because your logic's entirely right. It doesn't matter what LCL did. But what LCL did, in a sense, provides the vehicle by which Mr. Griffiths addresses this point more generally. And his evidence is, well, this is subject to the error in the details. Essentially, that process is one that an alternative lender would undertake.
But it does have this slight artificiality, doesn't it? That if the lender, as in LCL's case, has a centrally imposed default rate of 4% per month, then depending on the underlying loan, that rate may or may not be a penalty. It depend on the LTV, the interest cover,
well, in a sense,
the income cover.
I suspect that must be right, my lord, and one can take an extreme example of that. Supposing this were a routine 25-year residential mortgage at a conventional interest rate of base rate plus 1% or whatever it may be. Plainly, if one said in that sort of context, we're going to move to a default rate of 4% per month, one would be looking at it through an entirely different way, because the nature of the loan that one makes to start off with is critical. Whereas this isn't that sort of loan at all. This is short-term bridging lending at a high initial interest rate and such all the sort of usual risks and difficulties that one has with that sort of loan.
But would that lead you into a sort of situation that in the Parking Eye and Beavis case, the amount charged for overstaying would be a penalty in some car parks and not in others? I mean, that's the...
Well, that may be right. I mean, it may be right. I think one would. I mean, one can imagine saying that a busy supermarket car park in the middle of a city, one would have a different approach to a isolated rural car park. One can see there might be an argument on the facts about that. If there's any difficulty with that, though.
I don't think that was, well, I need to go back and look at the way the Supreme Court looked at Parking Eye.
I may be misremembering, but in principle, my submission would be, but in a sense, it doesn't matter for this case. Yeah. Because this case is inevitably, and always has been, there's no dispute that it has to be focused on the particular nature of the loan in question. And that's what the experts are focusing on. That's why they say, and I think your Lordship was slightly surprised at the monthly rate of 2 or 3% compounded. But that's what they're saying is typical in these sorts of loans. Obviously, it's not typical in other sorts of loans, but we don't need to worry about that because we focus on this sort of loan. So that's, in a sense, what the judge said about Mr. Griffiths. Just to pick up on my learned friend's 3 errors that he relied upon. The first was to say that it's wrong to take account only of the Downhill's Way income, and I think I've addressed that point. It doesn't matter that LCL made a mistake. Then he complains about what's said at paragraph 325 on page 160 about the evidence of Mr. Theophanous. And Mr. Theophanous was talking about the impact of the occupancy of 71 Hamilton Road. And the point of paragraph 327 is that any new lender would regard 71 Hamilton Road as less attractive as security if occupied as a family home. And that would impact the LTV that they would want. But he then goes on to say, well, the interest cover is still met, even in those circumstances. That's what he says about not attaching weight to Hamilton Road not producing income, because he says the interest cover was achieved, albeit the position was quite marginal.
So where are you looking at now?
327, Lord.
327.
And so it's really not very clear that that point has much significance at all, or that it really goes anywhere in all of this. And then the third error that my learned friend relies upon is the reference to later events, the reference to what Kent Reliance did in 2023 in terms of their refinancing offers, and a reference to the movements in the Bank of England base rate. But of course, all these is examples by reference to things that did happen, of things that must have always been known to any lender, potentially could happen. Obviously, Bank of England base rates are liable to move, and lenders.
The argument against you is that's not what the judge says. He doesn't say, well, of course, any lender always knows that bank rates are liable to move. He says, well, in 2003, they went up to 5.25%.
Yes, but he's still coming back.
Seems to be hindsight.
Well, it's not though. I mean, it's not in terms of what he's asking. He's asking that he's looking at what a reasonable lender would conclude in July 2020. And he says that the reasonable lender would probably conclude there's no or almost no margin for error. And the point is that what these illustrate is how readily the balance can be tipped. Relatively small events can have a big impact on the ability to refinance. And he gives those by way of example, but that any lender in July 2020 looking at this would know, would consider the lending on the footing that they have to take account of possible changes in the lending environment that may happen in the future. That's really all the point amounts to. Lender isn't going to lend
On the HMO point, I understood that Mr. Cowan accepted that the possibility of letting one of the properties as an HMO was not in itself an illegitimate point for the judge to take into account,
Yes.
but only if he assessed its probability. I think that's what was said yesterday.
Well, but it's not about the probability of that particular event. Because if one starts doing that, one really is looking at it from a hindsight perspective. We know this event happened. What's the probability looked at from the perspective of July 2020? The question in July 2020 is how much margin for movement is there? How much margin for change is there in the future as regards the position that a new lender will be looking at this in a year's time as compared with the position today? And where you've got limited margin for error, scope for things happening obviously becomes more significant. And the significance of those things that may or may not eventuate matters an awful lot. So if you have higher base rates and then a default by the appellants under some other loan agreement, the new lender is going to be looking at things from a very different perspective than existed in July 2020. That's the point, and that's why it's not a hindsight-driven point. It's a point, and you don't need to look at things. You don't need to ask about the particular probability of particular events. One just needs to look at, well, what's the risk here of change? And the risk is high. There's then, I've touched on this slightly, I don't know to what extent I need to go back to it, but the question about the cross-examination of Mr. Griffiths and the judge's interpretation of that, and the point about Mr. Griffiths referring to 4% a month as a huge, huge penalty, and the judge saying, well, that's not something that can be taken as a reference to the strict legal test for penalty. And that is an unsurprising conclusion. If one looks at what Mr. Griffiths was asked to address, and that's just at page 98 of the supplemental bundle.
'98.
98. The bold heading of 4, 3 paragraphs up from the bottom. You see the question that Mr. Griffiths was asked was what were the market rates of interest and default rates for this kind of bridging loan? So he was asked, he wasn't asked about the test for a penalty, he was asked about market rates. That, at page 100, is where he turns to default rates and talks about a low single-digit monthly default rate as being a commercially acceptable rate. On page 101, paragraph 3.89, says it's for the court to decide what properly constitutes a low single month default rate. However, my opinion, 4% appears to be at best the upper extremity of that band and is outside it. And then at 390, he goes on to address the question. The question remains what would constitute an appropriate and reasonable default rate? That's what he's focusing on. Entirely different question from the question of what constitutes a penalty as a matter of the legal test. So when he says, when he's cross-examined, well, 4% is a huge, huge penalty, very difficult to take that as meaning penalty in the context of the legal test, particularly when, as the judge pointed out, the legal test was then put to him and he didn't give a direct answer saying that, well, yes, 4% is plainly extortionate or anything of that kind. So the question on this point must be whether the judge is entitled to make the findings that he did in the way he interpreted the evidence. My submission is that he very plainly was. Can I just say something, just come back to the question of procedural unfairness that my learned friend relies upon, and the suggestion that the remedy for that might be remittance, yet a further hearing. Perhaps it doesn't come surprising to the court to hear that wouldn't be welcome by clients. LCL would be kept out of its money, and indeed any money, for even longer than it already has been. It would incur further costs with no opportunities for recovering those, given the disparity between the value of the security it holds and where the level of the debt already is now. And the more central point is that remittance wouldn't resolve the central difficulty that the judge faced, which was the mismatch between the way in which the appellants argued their case on this point and the evidence that was put forward. If this case was remitted on the same evidence, that point, that difficulty would necessarily arise again. It would be remedied only by putting further evidence in that did address the issue in line with the way the appellants now argue that case. But that need for further evidence, in my submission, just demonstrates that the problem here isn't any procedural unfairness. It's the failure of the appellants to align the way in which they argued the case with the evidence before the court. And their failure to follow through on the implications of their position that each legitimate interest had to be addressed individually. There's no injustice there or procedural unfairness in my submission. On the contrary, it would be unjust to LCL to force them to go round this whole argument again in order that effectively the appellants would get a second or even third chance to put forward evidence on this point. That would really be the only purpose of it. And that, in my submission, would be an unfair outcome. One can't conclude, in my submission, that the judge got it wrong in his evaluation of the evidence. The test, my learned friend doesn't even seriously attempt to meet the test set out in Sprint Room. He can't show that there's any error to that of that nature in the way that the judge reached his conclusions. And so therefore he can't persuade the court in my submission, can't demonstrate to the court that the alternative answer ought to be substituted for the one that the judge gave. And on that basis, the ground of appeal ought to fail.
Yeah. I mean, you say that the remittal hearing was not unfair, but supposing you're wrong about that, if it was unfair, we have no choice but to remit. We can't say, well, that's a great hardship for LCL, can we?
Well, if it were unfair, I think that probably is right. But my point is more the sort of further point as to whether that would actually address the point, whether that would address the issue at all. And the answer is, for the reasons I've just given, it wouldn't, unless you remitted on the footing of everyone putting in new evidence.
Yeah.
And that would be really not just saying we need to rehear because there was some procedural unfairness in the remitted trial, but the proceedings more generally need to be revisited. And the reason for that, as I say, lies purely with the appellants and the way they've argued the case and the way they put forward their evidence and the fact that the two don't align. And having approached the matter on that basis, well, they have to accept the consequences of my submission. Nothing unfair about that. That then takes me on to statutory interest, which is the final point. Obviously, very much by way of a fallback, contingent on the court being against me on the default interest point. And of course, because it's a fallback point, the judge didn't deal with it at all. There's nothing from the judge. There are really two aspects to the issue. First, the question is, does the court have any jurisdiction to make an award of statutory interest? And then secondly, if so, what rate should an award of interest be set at? As to the question of jurisdiction, of course, in normal circumstances, if there's no applicable contractual rate in respect of a debt, then it's entirely routine for the court to award interest under Section 35A. What the claimants rely on is Section 35A(4). If we invite the court to turn to page 3 of the authorities bundle behind tab 1. Subparagraph 4 of paragraph section 35A says that interest in respect of a debt shall not be awarded under this section for a period during which, for whatever reason, interest on the debt already runs. And my learned friends say, well, the claimants have the court has no jurisdiction to make an award under section 35A because contractual interest is already running. In other words, they're asking the court to conclude that the contractual interest is unenforceable as a penalty, but nonetheless the court should treat the contractual interest as effective for the purposes of section 35A to exclude the power to award statutory interest. Now, if the court were to do that, it would necessarily be giving some effect to the contractual rate. It would be saying that the rate had some legal effect because it had the power, it was effective to exclude the court's power to award statutory interest. Now, in my submission, that would be entirely inconsistent with the finding that the contractual rate was a penalty, which would make it contrary to the policy of law and wholly unenforceable. It would be an inherently inconsistent approach in my submission. There is no direct authority that either party's identified on this particular question. There are authorities that deal with the usual impact on the finding of a penalty as regards alternative remedies and on the effect and the intent behind section 35A(4) more generally. And perhaps I can take the court to those. I note the time, it may be convenient
Right, well, should we
to
do that at 2 o'clock?
do that at 2 o'clock more.